All right. Thanks, everybody, for coming. Thanks for coming to today's event. As you know, we're going to highlight today and hear from the authors of an article that just appeared in the American Journal of International Law. I'm Kurt Bradley. Professor Helfer and I are the co-editors-in-chief now of the journal. It's also called AJL, American Journal of International Law. It has been operating for a little over 113 years, and it's the only peer-reviewed international law journal in the United States. It covers a wide range of international law topics in the scholarship that it publishes. It also, each time we have an issue, covers the latest practice of the United States in international law. I can tell you that the editor of that section is very busy the last couple of years. We also have book reviews of leading books in international law, and also an account of some of the most important decisions of national courts from around the world on international law topics. In about the last 5 years or so, we've also had an online component, which you can find on the web. It's called AJL Unbound, and about once a month it publishes a symposium of short essays on various cutting-edge topics. Just to take one that's online right now, Europe's recent data privacy initiative, a bunch of essays about that, but there are new topics every month, and we also use that space for symposia on the articles that have appeared in the journal, in a number of cases. It's quite a privilege to have the journal housed here at Duke Law School. Professor Helfer and I have tried to look for ways to include students in the fact that we have this opportunity at Duke. So among other things, each year we employ about 7 students at Duke as submissions editors, and they are listed, in fact, in the masthead of the journal, and they play an important role in particularly screening the manuscripts that we get. We get about 400 or more manuscripts each year coming to us. We're only able to publish as lead articles about 8 or 10 of those a year, and so screening and figuring out which ones are the really promising manuscripts is an important part of the job, and the students play an important role in that. But we also thought maybe there are other ways to connect what we're doing in the journal to the students at Duke, and so we have this idea. This is actually our inaugural event for this new program, is to bring some of the authors of these lead articles, we only have so few each year, bring them to Duke and have them talk with you about the work that they've just recently published in the journal. The article, and Professor Helfer will introduce our authors today, just came out in the journal. It's called "The Proof is in the Process, Self-Reporting Under International Human Rights Treaties." So Professor Helfer will now introduce our speakers.
Good afternoon, everyone. Thank you for coming to the lecture. It's a real pleasure and a privilege to have Cosette Creamer and Beth Simmons here with us. I see a lot of my students out in the audience. I know some of you have asked me, and I get asked, quite regularly, how is it that international monitoring mechanisms, how do they actually change the behavior of states if they don't have any real enforcement power? And one answer to that question is that the government officials who engage with international experts that are tasked with reviewing their conduct, that engagement creates a process of information sharing, of socialization, of providing opportunities for advocacy by civil society groups, and that then leads to pressure on governments that helps them to live up to their treaty commitments, at least in part. And I can't really think of any two better scholars to address this issue than Professors Creamer and Simmons. Just a very brief word. Professor Creamer is an assistant professor of political science at the University of Minnesota, also affiliated with the law school there. Professor Simmons teaches at the University of Pennsylvania, where she's the Andrea Mitchell University professor in law, political science, and business ethics. And both of them are interdisciplinary and wide-ranging in their scholarship and research in multiple senses, not just the intersection of law and social science, not just different types of theoretical, doctrinal, and empirical work, but also a focus across multiple issue areas. So not only are they experts in international human rights law and institutions, but also in the variety of international economic law bodies, questions of refugees and migration, human trafficking, the list really goes on. So I'm eager to hear their presentation of their paper. We're very excited to have published their paper in the American Journal of International Law. So please join me in welcoming Professors Creamer and Simmons.
Thank you. you. Thank you very much. That's a perfect introduction because what Professor Helfer really put on the table is this issue of how does monitoring and enforcement actually work in human rights. And I'm sure that most of you have heard that the answer is not very well, essentially. And that essentially these are very weak mechanisms. That the common wisdom really is that the whole treaty structure surrounding international human rights is potentially in crisis, that it hasn't lived up to expectations. There's a weak system, partially because it really has no teeth. And that's the kind of common wisdom that we want to take on. And we want to take it on, but we insist that we do it theoretically, and we insist that we do it with evidence. So that's what we're trying to do in this article, and you're going to get a good, I think, flavor of that through this presentation. But the literature out there is really bombarding us, I think, with criticisms of the international system of human rights and the role that law has played. And it has, in many ways, been quite a negative kind of a literature that see the system of treaty law as irrelevant, perhaps, to human rights practices, or possibly worse, creating harms of various kinds. And given all these dire reflections, essentially, this is the question that we take on in this paper. We ask, for instance, has the International Human Rights Treaty system failed us? And our answer basically is no. And we insist on providing the evidence or providing suggestive evidence for why that should be true. This paper actually comes out of a few other studies that we're doing as well, and we're going to touch on those as well. But we think that the rhetorical strength of a lot of the existing studies and literature is stronger than the evidence that they present. And so that's really what our main goal is to, that's what our intervention is here, essentially. People mobilize to demand their rights under human rights treaties, but treaties also contain gentle enforcement mechanisms, and I do insist gentle enforcement mechanisms. Not exactly teeth, I don't know, gums maybe, but gums are not irrelevant when it comes to having consequences and having effects. So we argue that the strongest formal mechanism within the treaty structure that is being used is the mechanism of self-reporting, in which states present their efforts and report on their efforts to try to implement treaties to oversight committees. The literature tells us that this is a practice that's inherently weak, that it's a whitewash, and that it's meaningless. And so that is what we want to try to line up some evidence for you on today. Now, we've done some previous work on this. The article that was published in the Agile really gets at why one might think theoretically, through the process of reporting, that the treaty mechanism of self-reporting might make a difference. But it's really built on two other studies that we've done. We found, using quantitative evidence in sort of two other sources, that reporting does matter. There is good cross-national statistical evidence to show that repeated engagement with treaty bodies has contributed to lower levels of discrimination against women, for example. We have that article published here in the Law and Contemporary Problems, Journal of Law and Contemporary Problems, published here at Duke, and Physical Integrity Rights, which we published in International Studies Quarterly. The important message that if you have a chance to ever look at these articles here, the important thing is that one shot doesn't matter. You turn in one report, you don't automatically sort of turn into a better practitioner of human rights, but the accumulation does matter. And we found that the more states participated in the process of report and review, the more their practices actually did improve over time. The effects are not massive, as we would not expect them to be, but they do accumulate, and they create very important nudges for treaty compliance. That's what those studies suggested. Now, what we're going to talk about today is the article that came out in the American Journal of International Law. The proof is in the process. So the previous studies essentially sort of showed a very strong and convincing correlation between participation and improvements on the ground. And this treaty digs into why that is the case. It really looks under the hood a little bit more. And we offer essentially 4 kinds of mechanisms that potentially could explain why it is when a country or a state participates in the process, they actually do improve in their behaviors over time. And the mechanisms that we're going to elaborate today have very strong theoretical grounds in the social sciences, some of them in psychology, and obviously as well in political science. And we can also bring some pretty strong evidence to bear on these mechanisms as well. So the mechanisms that we're going to talk about are learning best practices. Through this process, states actually learn how to implement and what works and what doesn't work. They do get socialized in an atmosphere of persuasion, and we can look carefully at the language of the give and take, the back and forth, to find evidence of that. We will show you that there's mobilization of the public around the reporting process, and we will show you that there's a contribution of the reporting process to processes of law development. So if you want to think of it, that's sort of an influence multiplier, if you will, to this reporting process. So we found systematic evidence of all 4 of these mechanisms. We can't do this all today because we have short time, but we will provide a flavor of what we came up with. And now I'm going to turn it over to Cosette.
Thanks. Okay, so what does this human rights treaty body system look like? So for those of you who have taken international human rights law or public international law, you might have a sense of what these committees are, who these committees are. But basically, every one of the core international human rights treaties establishes what's called a treaty body or a committee. And as Professor Simmons mentioned, these treaty bodies, these committees, they're tasked with overseeing, monitoring, implementation of treaty obligations. And they're composed of a range of independent experts who are nominated and elected by states parties to those treaties. So here, for example, is CEDAW, the Convention on the Elimination of Discrimination Against Women, CEDAW's committee meeting this past fall for its 74th session. And I'll talk a bit about the treaty bodies have a bunch of functions, a number of functions under the treaty. But we only focus in this article on one, which is one of the ones that we think contributes the most to nudging states in the right direction. And that's the process of reporting to the treaty bodies, or self-reporting. So Professor Simmons talked a bit about it, but what exactly does this reporting process look like? Well, first, governments that have ratified a given treaty collect a bunch of information. They prepare a report. The reports used to be really, really long, like ranging in the hundreds and a couple hundred pages. They're much shorter now. I think there are page limits now on these reports. But they engage in a lot of internal discussion and collection of information about various laws on the books and practices to prepare this report and submit it to the treaty body or the committee. The committee then reviews this report. So what do the reports look like? This, for example, is Argentina's 7th report to the Committee on the Elimination of Discrimination Against Women, the CEDAW committee. And it contains a lot of substantive information. A lot of the critics out there think this entire reporting process doesn't matter because governments can whitewash. They're not really doing a thorough job of collecting and presenting this information. They're not taking it seriously. But that's not true. We've read through all these reports, and oftentimes the reports will compile relevant laws to treaty obligations. So here, for example, Argentina is reporting on how it amended a law to sort of include, to address ways in which it was departing from CEDAW obligations. And it also collects statistics, such as the number of women victims in a given year that were rescued by virtue of that law from human trafficking, or maternal mortality rates. And further, these reports typically tend to include information about new institutions that are created, right? Because it's not just about changing laws on the books and ensuring that those laws actually have effects on the ground in terms of practices. Implementation of international human rights law also requires the creation sometimes of new institutions, such as here, where Argentina, within its National Women's Council, created an entire new division to focus on health and women's rights. Importantly, the committees don't just receive information from states parties. They're not just receiving information from governments. Civil society also submits their own alternative reports to the committees when a given state has reported. These are called shadow reports, and Professor Simmons will talk a bit more about them later. And the shadow reports often pick up, these civil society reports often pick up and flag information that the state reports failed to mention, that were not covered. And it's the committees actually use this information. They use the information provided within the shadow reports during what's called a constructive dialogue. So after the committee has received all this information and these reports, it invites the government to come to Geneva to appear before the committee in a 2-day constructive dialogue. I did not make up this phrase. This is actually what it's called, what the International Human Rights Treaty system calls it. And it's basically a series of back and forth questions and answers between the committee members and government delegation, the representatives from the government that are sent to Geneva. And at the end of this 2-day back and forth, the committee issues what is called a set of concluding observations or recommendations. And within these, this is basically what the committees, the treaty bodies are recommending, right, not ordering, recommending that the state do, how to change a given law, adopt a given policy to better implement, to better improve its compliance with its international human rights law obligations. There might be some follow-up. The state might have to submit a follow-up report or answer some questions. And then has to do this all again about 4 to 5 years later. And it's a very time-intensive process. Oftentimes can take over 1.5 years for this entire process to work. And importantly, governments go through this same process independently for every single one of the 9 core international human rights treaties that they have ratified. So if you ratified all of them, you're doing this 9 times every 4 to 5 years. So as with international human rights law more generally, the treaty bodies have faced a number of significant obstacles. They're severely under-resourced. The budgets of these bodies are very, very limited. They almost had to cancel meetings this past year because they just didn't have the money to hold them. A review of these governments, the constructive dialogue, they lack any real means to effectively compel governments to submit reports, to show up, to implement the recommendations. In short, as summed up by political science professor Emily Hafner-Burton, the reports often don't seem to lead to results that matter. That, at least, is the conventional wisdom. So in light of all of these challenges, the former High Commissioner for Human Rights in 2009 initiated a process called the Treaty Body Strengthening Process. And the General Assembly in April of this year will review the effectiveness of reforms that were adopted in 2009 to consider their effectiveness, whether they have actually contributed to the strengthening of the treaty bodies, and importantly, we'll also consider adopting additional reforms or changes to the entire treaty body system, including the self-reporting process. And as social scientists, we who are sort of interested in generating relevant policy recommendations, we think that's important to sort of that any of these reforms are based on evidence about what works about the process and what doesn't, and are geared towards reforms that will strengthen or improve what does work about it. So does reporting to treaty bodies matter? Professor Simmons indicated, yes, we found that they do have these positive effects. We collected a lot of data. We basically collected all of the reports submitted under 4 human rights treaties. We couldn't do it for all of them. The CEDAW, as I mentioned, the Convention Against Torture, the International Covenant on Civil and Political Rights, as well as the Convention on the Rights of the Child. We read through all of these reports. Well, not just us. We had a team of RAs, of research assistants, read through all of them and coded them for how thorough they were, how transparent, how forthcoming governments were about, for quality, how forthcoming governments were about where they were falling short. So not just the positive things. We coded them. Higher quality reports for us were reports that were more forthcoming, that sort of provided more mea culpa. No, right? Our criminal code doesn't define torture in the same way that it's defined within the Convention Against Torture. We also coded all of these reports for the degree to which they were responsive to committee concerns or recommendations from the previous round. So on this figure, we're going to show some of this data for the CEDAW. What we did was, as I mentioned, we coded along a number of dimensions for quality, implementation, changing laws, the extent to which the government was forthcoming about compliance, about there being just sort of practices on the ground that violated treaty obligations, whether it provided statistically relevant information, as well as how responsive it was to the treaty bodies. So here we have implementation, compliance, and data, basically the quality scores averaged across all reports submitted in a given year, and as critics would expect, it was really low, right? 8 is the highest a report could receive. It was really low in the early years. But after about 1991, unlike what the critics would expect, right, we see drastic improvements in how forthcoming, the quality of these reports, and even greater improvements in the degree to which they are responsive to and address questions and recommendations that the committee had made in the previous round. So how is it that reporting has these positive effects on human rights? The proof, to butcher a really old saying, is in the process. The saying is actually the proof is in the eating of the pudding, not the proof is in the pudding, but we think the proof is in the process.
Right. It's very hard to do data in 20 minutes.
Yeah.
But nonetheless, I think that's really an important part of what we wanted to contribute to the literature. So what is it that is potentially at play here? And these are the 4 mechanisms that we examine in the paper. 2 of them are in the room, essentially, what we mean by that, among the players themselves, the first 2. The second 2 are how this process escapes the room. That is how it gets out into the kind of more public realm. I bet you all we're going to have time for probably is to talk a little bit about what the data look like on, let's say, public attention and mobilization. Let's concentrate on these 2, but it could be that all we have time for today is to talk about public attention and mobilization. So critics assert, of course, that those that are most affected by human rights treaties violations never know what's going on in Geneva, never find out what's going on in Geneva. Stakeholders are separated from the process, essentially. So we found, essentially, this is not necessarily the case, at least most of the time. So we looked at, for example, 2 sort of sources of looking at this. The reporting process elicits information from civil society actors, and so we looked at that very closely. They make shadow reports, they meet with local treaty bodies, and we found essentially good evidence that interactions of civil society and local organizations intensified over time. So in fact, what happens in Geneva doesn't stay in Geneva. NGOs form. They form particularly to participate in this process, and we can systematize this essentially over time by reading all of these shadow reports and trying to say something empirically about the patterns that we find there. So what this is going to show you essentially now is that from 2007 on, which is the only sort of time period which we could systematically find comparable access to the shadow reports, we're going to show you how much these increase over time, and we're going to show you the division between local versus international, because our main kind of thought here is that when local actors get more involved, it creates a more constant kind of a pressure and process. So what we have here are the 4 treaties, essentially. The skeptics would maybe make us expect local groups to give up participating. What's the point? It's a whitewash. This is all meaningless nonsense. They might grow cynical. And instead, we find very different patterns. Very different patterns. So here are for the 4 treaties. We find these are the numbers. Average number of civil society organization reports each year for the 4 treaties. And there are 2 things I really want you to focus on here. One is the existence and especially the intensification and increasingly the domesticness of the scrutiny of these state reports. So these shadow reports increasingly are being very connected with what's going on locally in most countries. So, you know, they bring up important things too. So, for example, during the self-reporting process, domestic groups in Argentina revealed abuses about women in prisons at the hand of male prison staffs. It makes its way into the discussions. They get questioned on it by the committee, and that actually makes its way into the final recommendations that the committee makes to Argentina. So what about a broader public, right? So not everybody's in a CSO. CSOs have to get their messages out too. So what essentially we did was we tried to look at whether there was any evidence of the process escaping the room in the general media. So what we did essentially was we documented public opinion, public attention in the form of local media coverage, discussion in the local press, reporting on the process of the reporting process and the review process. We searched the local major press outlets for 15 Latin American countries for the mention, any mentions about this process for all available years, and we were only able to do this for 2 treaties, though, essentially, the CEDAW and the CAT. And so what we have here essentially is media attention in Latin America. 0 means the year, that's kind of a year of the reporting process. So we're showing you the few years before and the few years after. If you're a skeptic, you're not going to expect to see any kind of peak there. Nobody's paying attention, right? It's going to be low, it's going to be flat, and it's going to be constant. So that's essentially what we found. The takeaway is that this is not consistent with the idea that what is said in Geneva stays in Geneva.
So finally, another thing that we looked at for evidence that the sort of domestic individuals are paying attention is attention by government officials who, particularly those who are not from the executive branch, who are in the room with the treaty bodies in Geneva. Are they involved in this process? How? And so what we did was for 4 countries, we searched the legislative records of 4 countries in Latin America for evidence that legislators, right, those who actually have to put in place laws to implement treaty obligations, that legislators were referencing the treaty bodies and their recommendations when introducing bills, for example. And so, for example, for Argentina, Argentina was one of the 4 countries whose legislative records we searched. And so here on the y-axis, that vertical axis will show the percentage of the total number of sessions that referenced either the treaty generally or the treaty bodies and the reporting process itself. And we found that legislative attention in Argentina, at least, it was pretty low in the early 2000s, but did swell in 3 peaks. And Argentina is actually a hard case to demonstrate this. The other 3 countries whose legislative records we searched referenced, Mexico in particular, referenced treaty body recommendations for CAT and CEDAW much more frequently than Argentina did. And this is often in the context of introducing a new bill or putting forth a new policy. For example, when amending the Argentinian criminal code to incorporate violence against women or femicide in 2012, which the CEDAW committee had actually recommended in its previous review of Argentina, a number of Argentinian legislators from both the opposition and the incumbent party referenced these treaty CEDAW's recommendations. So one way, then, that reporting contributes to law development, right, is by providing information to legislators to actually use to provide an additional argument for why they should adopt a law, right, a country should adopt a law, or at least reform existing law. Reporting also contributes to human rights law development through another pathway, and this is the 4th mechanism that we talk about within the article, and that's through human rights courts. The treaty body issues decisions and interpretations that inform and reinforce the jurisprudence of regional human rights courts. So what we did was for two of the major regional human rights courts, the European Court of Human Rights and the Inter-American Court of Human Rights, we searched the case law of both of these courts for any reference to the treaty body output for 6 of the core human rights treaties, the oldest ones. So importantly, we didn't just search for a reference to the state reports that were submitted or the concluding observations or even the dialogue, because the constructive dialogue, the transcripts are out there, but also individual communications and general comments. And focusing on Latin America again, for the Inter-American Court of Human Rights increasingly references both state reports and the concluding observations or recommendations of the treaty bodies. Much more so, I should say, and we're not going to show you the European Court, but much more so than the European Court does. And so what we're not saying with this is that states necessarily always follow, right, these rulings, but right, there is a mutual reinforcing relationship here. So for example, turning now to Costa Rica, in a case that was brought against it, alleging that its ban on IVF that had been in place since 2000 was in violation of the Inter-American Court of Human Rights. The court here referenced a number of treaty body interpretations of CEDAW and the Human Rights Committee to basically find that this did violate Costa Rica's obligations under the Inter-American Human Rights Treaty. And this eventually led to Costa Rica, after 16 years, lifting this ban. So what sorts of policy recommendations flow from this? First, we're not saying that this treaty body reporting process is perfect. It definitely has its weaknesses. We're saying that it should be, and we encourage and support recommendations that are out there to rationalize it, to streamline it, to make it more efficient, but not to get rid of it, right? There are calls to get rid of the reporting process across treaty bodies by some governments. In terms of sort of strengthening this mechanism of domestic mobilization and domestic public attention, we support and recommend reforms that would move to holding these constructive dialogues not far away in the halls of the UN in Geneva, but within the Office of the High Commissioner for Human Rights, regional offices, for example, so closer to the people on the ground who might want to acquire information about what the committees are saying, what the treaty bodies are recommending. We think that there are other ways that the regional offices of the OHCHR can increase local visibility and accessibility through media releases, through accessible, digestible summaries of what the concluding recommendations say, social media, for instance. And we support a number of recommendations that have been made by governments, in particular, to promote greater dialogue through multiple meetings per year between the treaty body members and judges on the regional human rights courts. And on that note, I will end. Thank you. We have a bunch of other recommendations in the article that I didn't talk about, but that's what we have.
Questions? We certainly have time for questions, so I'm going to try to get the students first.
Sorry.
I was wondering, in the graph I was comparing the different treaties, like for CEDAW, it seemed to be like increasing in terms of like this, I guess, the countries, the way they responded. But in other treaties like the CRC, it just seems kind of stable. So I'm wondering, like, to what extent is it the topic and not really?
Is that the quality one you're talking about?
Yeah.
This one, this one, this one.
I'm just
That
wondering, like, to what extent is it actually like the mechanism system that's helping this, or is it more of the type of like the topic that's really generating this kind of movement?
Yeah, we didn't talk at all about sort of the differences that we saw across treaties, because you see differences in terms of what's in the reports too, right? It's much easier for a government, in terms of quality and responsiveness, it's much easier for a government to sort of say, look, I can't, I just don't have the resources to increase sort of gender equity in primary school enrollment, or I don't have the money or the resources to reduce infant or maternal mortality rates, than to sort of say, yes, our government officials are torturing, right? So you see that sort of difference across treaties in terms of their content, right? If it gets to something that's really central to national security concerns, for instance. In terms of the shadow reporting, there are a number of treaties that CEDAW and CRC in particular, which is interesting that we don't see as much increase in domestic civil society reporting within the CRC and CEDAW as we do with the ICCPR, because they're dedicated specialized CSOs that have developed around, right, that entire treaty and that issue area. So for ICCPR, here, so I should also say, and this was not mentioned, this drastically underestimates the number of domestic CSOs who are involved. Because a lot of these are small, they don't have a lot of resources to sort of engage in shadow reporting all the time. Each one of these shadow reports actually is a combination. It's a joint CSO report. It's a joint shadow report. It's upwards of 6 to a dozen civil society organizations coming together and writing one report. So this actually underestimates the level of domestic mobilization. Yeah. I don't know if that answered your question about
I'll just throw something else in there too. I mean, I think one important thing to realize is that this process of mobilization in particular is a political process. These different topics have different politics to them. Women's organizations have different motives and different means, essentially, to become organized compared to groups having to do with torture, for example. So the politics differ across these areas. Government responses differ across areas, and I think that's one of the really important things to keep in mind here, too, is this mechanism in particular is not a legal mechanism, right? It is a political one. We need to be thinking about what politics give rise to particular kinds of patterns across these areas. So I think, for example, that when women, women have this capacity to organize, and kind of it does tend to build quite a bit. And this one shows the clearest example of a local capacity for women as well to increase over time. And I think that's a very interesting observation to make.
The three of these are also specialized treaties, right? Whereas the ICCPR covers a much broader. That's why, in absolute terms, ICCPR looks so much bigger, because it just covers such a broad range of civil and political rights that you'd have these larger number of specialized.
So like death penalty, for example, goes under ICCPR.
Yeah.
So any group that wants to abolish the death penalty, that's where they'll be showing up.
So I'm interested in the idea of streamlining these reports, and I'm wondering, given what you're showing here, this looks like evidence that streamlining the reports, so perhaps combining different reports together would actually undermine the effectiveness of the reporting process. Is that what I should be taking away from this?
Yeah, so those aren't, this is an article in the conclusion, if you want to read it, but there are a number of proposals out there to combine the sort of treaty body report and review process. So, for example, have, instead of every 4 years or what have you, have every 8 years combining the ICCPR and the ICESCR together. And then in the second round, every 8 years, doing the rest all together, where you just have sort of, CRC committee members and CDAW committee members and other ones, CAT committee members coming together and reviewing. Every 8 years, not every 4 years, right, in a way that you even remember it's the same government, right, that submitted the last report. And we oppose definitely lengthening to 8 years the amount of time that falls between reporting requirements. We don't think it should go to 8 years, because we don't think it can have this sort of iterative effect if you only do it every 8 years. And we also, because part of why it works is this mobilization of specialized civil society organizations. As you mentioned, it's harder for them to then gain access to the treaty bodies and to the constructive dialogue if they're all clamoring for attention at that, like during one review.
Right. So I don't think we'd want to collapse the idea of streamlining. I mean, streamlining might be a good idea, depending on what one means by that. But to sort of make the reports themselves more accessible, I think is really critical to what we're talking about. But to have that involvement on an ongoing, closely periodic basis, because in our other work we've found that that is the clearest explanation for the improvements on the ground. And you can see why that is. Groups get their momentum going, right? And it's that participation, kind of having these sort of things periodically, frequently periodically, as a kind of a more public kind of a display that becomes important.
I will say, though, that just in terms of streamlining, what we do recommend, because first of all, Geneva is really expensive, right? So send an entire government team to Geneva multiple times over the course of 4 years costs a lot of money. They don't want to hold it, there's sort of cries to not hold it in Geneva, but we support recommendations, and we actually recommend as well to consolidate when a government undergoes the review for each of the treaties to which it has. So they can come to Geneva at one point in time, once every 4 or 5 years, and meet with the various treaty bodies for the treaties that they've ratified over the course of a week. And to that end, and this is another recommendation we didn't talk about, making the committees, sort of having committee panels. So it's not the full committee sitting there, but to lessen the workload on the committee members themselves, since they're all then in Geneva, to make it just almost more flexible, almost a more problem-solving type meeting with the treaty bodies. So that's another way in which we want to streamline the process.
To a negative impact on the individual media spotlight that you can get per treaty, though?
Yeah, and so that's a sort of a balance or a trade-off. But it would also help civil society organizations that shadow report up to multiple treaties as well.
Can I just add one little thing too, and that is that we didn't even talk about elite socialization, but that raises the issue of who's the appropriate elite to socialize. And one thing we sort of say in our recommendations is that, you know, people on the ground who are more responsible for policy development and implementation ought to be the ones that are going to some of these meetings rather than a diplomat, right? Who then doesn't take it home in quite as owned a way. It's really important for people on the ground who have control over a policy area, who have a lot of influence in a policy area, to be the ones that are socialized. So it depends on, I think we have, you know, pretty clear things to say about who ought to be attending these processes as well.
Bureaucrats, we want bureaucrats.
So I have a question in relation that if you guys have taken into account like probable biases when the central governments report to these bodies, because this, I would say that probably my country is just an isolated country, but then when this happens, so you have this report saying the country that they comply with everything, that everything is kind of fantastic, and there's just few changes that they need to do. But then actually the reality is quite different within the country. So for instance, I was thinking about Ecuador giving asylum to Assange, and then after this, our own internal laws, they repressed all the communication system. Mm-hmm. So people were actually afraid to even stand up or write an opinion piece on a certain newspaper because you would get basically harassed by the central government. But then on their national report, they say everything's fine. So I believe that this kind of biases should also be taken into account, especially in governments that are not clearly democratic itself.
You're from Ecuador?
Yes.
Okay. Do you want to answer this? Do you want me to?
I guess I'm trying to figure out what you mean by bias. We certainly believe that there are governments that do not want to comply. That's for sure. That's a given almost, you know. But what do you mean by a bias? I'm trying to get my head around exactly what the question is.
I would say that there's misreporting, so that they say they comply with certain treaties while they don't.
Oh, yeah. That's why it's really important to look at the shadow reporting, for example. So one of the ways that we're kind of conceiving this process is to say the report is one piece of information, and it is in a whole milieu of other information that is also triggered by and participates in the reporting process. So yeah, a government can certainly lie. The problem, the advantage of having a reporting and a review process like this is that a lot of other people start kind of chiming in about what else they're observing. And it's not just the shadow reports. We could look at various bodies in the UN, for example, that kind of participate on the sides as well, creating a kind of a whole set of information. So that's one positive thing about having a report and review process, is that it triggers a host of information processes that governments don't clearly control.
And that makes it hard for them to lie. We're not saying that every single report, when we coded it for quality and how forthcoming it was, listed every single thing that was wrong within that country, right? But it makes it a lot harder for them to say everything is perfect when, you know, they know that the treaty bodies are receiving these other pieces of information that dispute that, which makes it more difficult for them. They might still do it, right? But then it makes it harder for them to do it with a straight face, I guess.
Was related to politics, because for instance, this is very much related like to international politics and also internal politics. So for instance, in 2008, our former Minister of Defense, she was appointed the head counsel for the General Assembly. Her name was Maria Fernanda. But during that time that she was being appointed, she had a process within the country, a criminal proceeding, because she had violated human rights while she was the Ministry of Defense. So I would say that this has also like a political taint that probably is not reflected not in the actual reports or in the shadow reporting. So this, like for me, it's a very critical issue, because I would say that sometimes truth does not come out completely. Obviously, it does help the reporting process itself. I have no doubt in that. But I would say that certain factors have also, like, you have to take this other political factors into account to kind of have like a standardized or I would say neutral view of what is actually happening.
I mean, we're both political scientists. We're not going to disagree. We're taking it out.
But let me just say one other thing, though. I think it's really, really important when we put this study in kind of the broader context of research in this area to ask what is the counterfactual, right? So by counterfactual, I mean, what are we expecting to happen? Are we expecting, if we were to compare the findings of this study with nothing, our point is it's a lot better than that. But if your expectation is, I don't want to see any more human rights violations, no.
Perfect compliance.
We are not there. And that is by a long, long shot. Yeah.
I know that you mentioned that you look at the domestic law or domestic legislatures and see if they reference the law. And you spoke about 4 South and Latin American countries. But did you see differences across like Asia, which doesn't have a regional mechanism?
Doesn't have a
regional mechanism.
Right, where you don't have a regional human rights
we
court.
ran into problems of getting empirical evidence across different languages, the availability of documentation, and we simply had to make a decision based on just kind of what's realistic to do, that we could tackle one region in one language. And so we chose a region in which we know human rights have been problematic in the past anyway. We just had testimony, right? But so we know that much. But where we also know that we haven't sort of got a global sample that we can deal with here. And in fact, it could be very true that some of the processes we're talking about here potentially maybe are, in terms of legislatures and that kind of thing. Maybe they're more relevant in some countries than others. But we were just very much, I think, limited to what we could possibly accomplish empirically.
Can I add something to that? So not only did we sort of Control F search for reference, we then went to make sure it was an actual substantive reference that was meaningful, right, and not just randomly referencing a treaty, which involved reading like entire legislative records in Spanish to figure out what they were saying. And this is why we keep harping on there being empirical evidence to support any claims we are going to make about the effectiveness of this process, because this has taken us 6 years to get to this age-old. It's a lot of data collection and a lot of not just sort of crunching the numbers, but qualitative research as well.
Can I just add one more little thing? And that is that in this article, we have to be selective with the empirical evidence, because you can imagine when you're talking about process, there's just scores of countries that you could potentially look at. But the other 2 articles we put up there are global, and they control for things like region, they control for democracy, they control for the things that generally in cross-country comparisons you typically control for. And in fact, we have one article we didn't put up there that came out in Human Rights Quarterly that literally looks at who does quality reporting. So that's where we kind of look into those kinds of relationships. And we found it was very, very related to, reporting is very related to capacity. Whether you report at all is very related to capacity.
I will say, though, if you're looking for a research paper, topic, or question, that comparison between Asia and Latin America, I think it's a really good comparative case design, and we'll give you our Latin American data if you want to do the Asian part.
All this data are posted, too, actually. Yeah, they're all online.
So I have 2 questions that are linked to the process. The first of which is, as you mentioned, the UN does provide information to the committees about the country under examination. Were you able to track that in any of this in terms of how that related to effectiveness of the self-reporting mechanism? And the second question too, if you, back on the slide you had about reporting the state party and then the constructive dialogue, and a really key innovation.
This is a very simplified version.
I think a really important innovation has been the committees producing a list of questions to the state parties, which they then respond to, separate from this big multi-state report. So, were you impact of that innovation? Did you see anything different around that? That was quite not recent, but in your time period, innovation. And just a comment. I mean, I think many of us acknowledge who've been engaged with the treaty monitoring system. Either I've done it from the UN perspective, I've done it from the NGO perspective, and there are challenges with this system. I think one of the proposals you put forward of like having every state party report before every committee in a week is interesting. From an NGO perspective, I can see challenges with that. A really big one being that we're pretty strategic about which bodies we approach on which issues and how to build up incentives like through different treaty monitoring bodies, and so having them all together would really circumscribe that ability to engage with the bodies strategically. And secondly, I was really struck by your data on the international NGO and local NGO engagement in different bodies, and I'd be very worried about consolidation in 1 week, that gatekeeper NGOs would take over the engagement with these processes, and then in ways in which would exclude women's NGOs, disability rights NGOs, and so forth. Anyway, just something to think. I'm sure you've thought through that, but just that momentum you've described of having local NGOs more baked into the process is not accidental. I used to work for an NGO in Geneva whose our sole function was to facilitate local access of bodies to these local access of civil society to these bodies, and so just thinking through like how not to undo those trajectories that have been really hard fought.
So I think there's definitely a balancing act that because there's a lot of pushback by states to make it less burdensome in terms of their time and their resources, and we don't oppose recommendations that would say to have them all in 1 week or split them up, right? So, do half treaties, one that sort of tend to fit with one another in one session, and then half another session. Because I definitely think there is a trade-off there, particularly in terms of in-person access to committee members prior to the constructive dialogue, the review process, which is limited, and how many NGOs can actually sit in the room with treaty body members and talk to them and reveal information. In terms of the first question was on
UN information, like in this process.
Right. So this is the weird thing about the treaty body, what is it called? Treaty body database that the OHCHR has posted online, and this is why for shadow reports, for civil society reports, we only have from 2007 on, because they weren't way back they remained confidential, and they weren't reliably posted, all of them, online until around 2007. And you see the same thing with UN information, so that we didn't collect and code that, but that would be, do you want to write a paper together about that process? I actually went to the archives in Geneva and spoke to the archivist, OHCHR's archivist. She was saying how these shadow reports are like just a bunch of them are in boxes and they're not organized in the archive. And she said some former treaty body members have them still in their garage, and that was a lot to scan. So that's on that. We didn't look at that, but that's definitely one of these other alternative sources of information. So we have some thoughts on the list of issues prior to reporting. And so what Professor Huckabee was mentioning was that it was a few years ago, and not all treaty bodies have done this, and they haven't done it all consistently, but instead of doing a full-blown report for each treaty body, the treaty body would first send the state a list of its sort of priority issues or questions that it had. And the state can then, instead of developing itself a report, just respond to those lists of issues or questions. And it's a much more streamlined report that gets generated, and that counts as the state's report. So the dialogue then also becomes much more focused, which we think is another way that it can be rationalized and streamlined. So we support, right now the treaty body chairs have been coordinating to actually have this be consistent across, the working methods be consistent across treaty bodies for all of them to adopt it, or at least make it optional. I think at this point they've now all made it optional. We only have a few years in there of like really inconsistent use of that mechanism, but I definitely think it makes it more focused, which is another big issue, and then allows for the treaty bodies to coordinate the questions that they're asking so that there isn't a lot of overlap, which potentially has downsides too, right? Especially if you're trying to get different treaty bodies. But another complaint by states is that you know, we have these overlapping reporting obligations. The treaty bodies keep asking us the same thing, even though it's different treaties. Yeah.
But I guess the other thing I would just want to add briefly is we're kind of use the word streamlined to mean a lot of things, right?
Yeah.
So I think what our evidence though suggests is that there's a kind of streamlining you do want to do and a kind of streamlining you probably want to be careful with. The streamlining you do want to do helps to facilitate the two processes we didn't even talk about, the socialization and the learning of best practices. Because what that kind of streamlining would do would be to help states focus and prioritize. You know, and then they can't sort of fall back on, you gave us a list of 179 things to do, of course we couldn't do them all. You know, so and that's the kind of streamlining that we think is going to help with the first two processes that we talked about. But the kind of streamlining you really have to watch out for are the kind that interrupt the out-of-room processes. So that would be anything that limits access, anything that causes demobilization and exhaustion, anything that undercuts the capacity for participation, those kinds of things. So it really is this kind of careful balance between kind of accommodating the first two processes that so clearly involve states being able to focus effort, and the other two which have a lot to do with public access.
I think we probably have time for one more question. Yes.
This might tie into those first two processes that you skipped, but I was just wondering if you could talk a little bit more about when you said that it's better to have the people in the room who are actually making the decisions as opposed to setting diplomats, because the intention or the idea is to spread best practices from the treaty committees to those actually implementing them. Were you thinking of politicians, legislators, people implementing the policies and how that would kind of work? I just kind of want to hear.
High up national commissioners of police might be a good idea when you're talking about torture, it seems to me. So people that have to do with the policy area at a high level, but who are sort of charged with its broader development nationally and keeps an eye on these sort of implementation issues on the ground. It seems to me that would be kind of the ideal target, for example, for the case of torture, for example. So that's kind of what we're thinking, are people that have that kind of perspective and responsibility for purposes of both socializing about what's right here and also just for learning the best way to actually do things, should they want to do them, right? We shouldn't always assume that states are totally resistant to these ideas. Sometimes it is a matter of learning the best way to implement.
Yeah. So maybe we have slightly different perspectives on this in terms of how high up. Like, I actually think the technocrats and the bureaucrats should be like those who actually have to go back home and design that policy or design that law. You need both, right? You need the higher up officials who are sort of in that issue area. But if you're learning best practices, right, and you're learning what works and what doesn't work, and you're being taught this by the committee, you're effectively, we kind of want to move the dialogue to a more problem-solving, flexible style anyways. That's one of our recommendations we didn't talk about. But if those who are involved in developing and implementing the policy with respect to children's rights, for example, are in the room, as well as the higher-ups to get socialized, that's when that dialogue can actually turn into a back and forth that's problem-solving and not, what do you have on the books? Why aren't you doing X, Y, and Z? Which is what some of the dialogues now look like. And there's sort of been recommendations to move it towards this more. Can we ask questions to the committee about what works and what doesn't work? So we just don't know how to implement this treaty obligation.
So actually, I don't think we disagree.
Yeah.
I was trying to, that's exactly what I agree with. But there's another thing to actually remember as well, and that is that the dialogue for learning is two-way. So that it's not just a matter, for example, of someone coming in from a country who's involved with implementing policy, coming in and learning it from the committee. The committee needs to learn about constraints. The committee needs to learn what's possible. And literally needs to learn what works on the ground too, because it's just not full-blown in your head what's going to work unless you kind of gather experience on the ground at the same time.
See what a broad range of countries are doing, which some treaty body members think that that's what they're doing. We actually fielded a survey to all former and current treaty body members to ask them whether they thought that they were learning best practices in a given issue area across countries through the reporting process. And there's some disagreements about whether they are.
So we're basically out of time. I just want to say one comment, really, which is that, thinking about how you do this going forward, the flexibility is important, sort of learning what doesn't work,
Yeah.
but also learning where your red lines are. So for example, it would seem to me that particularly after you've stopped collecting data, we've seen a real trend among some countries, so Russia,
Yeah.
Israel, China, there are others as well, to limit civil society groups, right, and local civil society groups, and make it more for foreign registration requirements and all sorts of things. Those countries, right, if your sort of the mechanisms that you're talking about are working, those might be countries where over the course of the next 5 to 10 years, we might see real declines
Yeah.
in how the reporting process is working. So if you take civil society and the shadow reports out of the equation, and I realize this is not your paper, but if one were to extend this, there are some hypotheses that come out of this about what you would expect to find as states engage in repression, and where you're going to expect to see resilience, and where you're going to expect to see sort of diminution in effectiveness, and then also how the treaty bodies respond to that.
Yeah.
Where do they say no? This is not something we're going to compromise on. You have to deal with that. So
Yep.
I just put that out there. Anyway, this was a great discussion. Thank you very much. Please join us and thank you.
Thank you.